Welcome to Thursfields Talk Legal, a vidcast series from one of the leading law firms in the Midlands. I'm Steve Dyson, a journalist who's talking to a range of solicitors at Thursfields on legal topics of wide interest to the public or businesses. Please bear with us, as all recordings are currently carried out remotely online to make sure we keep to the government's social distancing advice because of COVID-19. Today's episode is all about redundancies, and I'm going to talk to Lisa Kemp, an Associate Director in the Employment and HR Law Department at Thursfields Solicitors. Over to you, Lisa.
Hi, Steve. Thank you for inviting me to talk to you today.
No problems. Lisa, I want to explore the tricky subject of redundancies with you and to focus on helping businesses through what can be quite a complicated process. So what's the first thing you would advise businesses to have in mind if they have to consider redundancies?
It's absolutely crucial that employers follow the correct procedure. So whether there are only a few redundancies envisaged or hundreds, it's always necessary to consult. So not following due process or selecting someone unfairly can lead to costly employment tribunal claims.
You said consultation was needed whether potential redundancies involved are just a few or a lot of people. So tell me about the difference in processes depending on the number of people involved.
Yeah, so when there are fewer than 20 redundancies proposed, the process to follow is far more flexible. However, when more than 20 dismissals are envisaged, an additional obligation, that is a duty to collectively consult, is triggered. Now, if that statutory obligation is not spotted or the rules aren't followed, each affected employee can bring a claim for a protective award of up to 90 days gross pay.
I see, so that's quite important to bear in mind. And what about the scenario in COVID-19, Lisa? Many companies, of course, have benefited from the government's furlough assistance to help retain jobs during the lockdown. But as the furlough starts to wind down, businesses still suffering may start considering redundancies. So what's the advice around this, given they've been helped by the government up to now?
Well, the usual rules around redundancy simply haven't changed. However, employees could now seek to argue that the redundancy process or their selection is unfair, whilst the coronavirus job retention scheme or indeed other government rescue measures are still available. Now, my take is that tribunals may be more willing now to examine the business rationale behind the redundancy dismissals when they're dealing with unfair dismissal claims. So employers should start thinking very carefully about this and whether there are any alternatives to redundancy available.
I get you. And what about market sectors that might be unable or certainly finding it more difficult to recover from lockdown as quickly as others?
Well, we know that some sectors have been more severely affected than others. Retail, leisure, hospitality, just to name a few. And of course, it may be that for those businesses, redundancy dismissals just simply can't be avoided, even whilst the furlough scheme is in place, and they may need to start planning now.
Staying with the pandemic for a moment, Lisa, even as the economy starts to emerge from lockdown, won't social distancing guidelines make parts of the redundancy process, like consultation, for example, impossible?
Well, the pandemic has created a situation where employees are on furlough, they're working from home, some are shielding or self-isolating or maybe practicing social distancing. And so that means the consultation process will look very different, with employers, embracing different technologies to hold consultation meetings with staff. So consultation will look and feel very different, but it certainly won't be impossible.
One of the main reasons for redundancy, of course, is for an employer to cut costs when certain trade or revenues have disappeared. And yet, making redundancies themselves costs an employer money, doesn't it?
Well, that's true. As well as notice and holiday pay, employees with over 2 years continuous service must be paid a statutory redundancy pay too. Now, that payment is calculated using a formula based on an individual's age, length of service and gross weekly pay. There are also important limits on the amount of statutory redundancy payment that is due to an employee too.
So individuals themselves, Lisa, if they're made redundant, do they have the right to appeal?
Well, there is no statutory obligation on an employer to offer a dismissed employee the right to appeal their redundancy. However, this is good practice and it could reduce the likelihood of employees bringing unfair dismissal claims.
Lisa, it's been fascinating exploring the topic of redundancies in so much detail with you. And for those watching, can you give me a quick takeaway summary of the most important things to remember?
Sure. Well, if redundancy dismissals are simply unavoidable, then taking timely advice to understand the legal obligations ahead is absolutely critical. And given the pandemic, planning how that process will actually take place and thinking about each employee's own circumstances and how those can be accommodated is now an additional consideration for all employers.
Finally, Lisa, if people need advice on redundancies, how can they get in touch with an expert at Thursfields?
Well, I can be contacted on 0345 207 3728 or on my email, which is alkemp, so alkemp @thursfields.co.uk. I'm also happy for people to connect with me on LinkedIn.
Lisa Kemp, Associate Director in the Employment and HR Law Department at Thursfields, many thanks for joining us on Thursfields Talk Legal.
Thanks, Steve. It's been a pleasure.
Hopefully what Lisa had to say about redundancies is something the business community will find useful. We'll be back soon to talk to more legal experts here at Thursfields about other interesting aspects of the legal world. Thursfields Talk Legal. Thanks for listening.